this event. I'm thrilled to welcome you all to this to celebrate Professor Michelle Adams' amazing book, The Containment. We're so grateful that Professor Adams has found the time to come here for this discussion, and doubly so thankful for Professor James Forman Jr. Both of them are taking time away from their next projects to be here, and we're grateful for that. The plan for tonight is for Professors Adams and Forman. We're eventually going to shift to first names, but for now we're still using Professor, to have a conversation about the book and the issues it raises, both historically and for today, followed by some Q&A, and then a reception in the lobby. But before we get started, I want to tell you a little bit more about our guests. I want to start with Professor Forman. He's the J. Skelly Wright Professor of Law at Yale Law School. If you went to his Yale Law School website, it's the second line of his bio that speaks to why we are so lucky to have him here today, because it tells you that he attended public schools in Detroit, in New York City, and Atlanta before receiving his undergraduate degree from Brown University and his law degree from Yale. Education, particularly for marginalized students, has been a central concern of his professional life. After graduating from Yale, he joined the Public Defender Service in Washington, D.C., where for 6 years he represented both juveniles and adults charged with crimes. And his experience as a public defender led him to found in 1997, along with David Domenici, the Maya Angelou School, an alternative school for school dropouts and youths who had been arrested. The school has been extraordinarily successful. It's expanded to run multiple schools inside DC's youth and adult prisons. It's founded on the belief that everyone deserves a high-quality education. Now, reflecting this experience, Professor Forman's scholarship focuses on schools, police, and prisons. And he's particularly interested in the race and class dimensions of those institutions. His first book, Locking Up Our Own: Crime and Punishment in Black America, was awarded the 2018 Pulitzer Prize for General Nonfiction. It's an amazing book. His second book, Dismantling Mass Incarceration: A Handbook for Change, came out in 2024. And so focuses on how to undo the damage caused by the carceral state. Now, I first met Professor Forman more than a decade ago at a conference, of course, organized by none other than Professor Adams here. And at that time, he was in the middle of the work that would lead to his Pulitzer Prize winning book. And in that meeting, that conference, it was brief in my professional career. And ever since, I'm so grateful for all I've learned from him, really. And so please join me in welcoming Professor James Forman. Now let me turn to our guest of honor, Professor Michelle Adams. She's the Henry M. Butzel Professor of Law at the University of Michigan. As we'll discuss in some detail later on, Professor Adams grew up in Detroit, and her personal connection to the city comes through in, I say, loving detail in this book, really poignant detail. Her research centers on race discrimination, school desegregation, affirmative action, and housing law. And she's here today because she's the author of The Containment: Detroit, the Supreme Court, and the Battle for Racial Justice in the North. And we'll talk about that title and why that title is so critical to the discussion we're going to have today. It tells the story, this book, of the critical desegregation struggle that, in Michelle's telling, Professor Adams' telling, ended the Brown versus Board of Education era. Now, like Professor Forman and me, it turns out she received her undergraduate degree from Brown University. She received her JD from CUNY and her LLM from Harvard as the first Charles Hamilton Houston Scholar. After graduating from law school, she clerked for Southern District of New York Judge James Francis IV. She too worked in public interest law before joining the Academy as a staff attorney at the Legal Aid Society, Civil Appeals, and Law Reform Unit. From there, she became a professor at Seton Hall and then Cardozo. And I met her when I joined the Cardozo's faculty, where she served for 15 years before leaving us for University of Michigan. And she was a treasured faculty here, treasured colleague. She won the Best Teacher Award in 2022. She was instrumental in creating a pop-up class during the first Trump administration that was received with wild enthusiasm by the students. She was the co-director of the Florsheimmer Center. She published widely and with great acclaim in the likes of the Yale Law Journal, the California Law Review, the Texas Law Review, among others. And of course, she's kept it up at Michigan. She's already won a teaching award, and she's produced this amazing book. Just speaking on a personal level, she's a dear friend. From the moment I walked through Cardozo's door, she was supportive. She gave me teaching notes that I still use. She tolerated my crazy and often naive ideas about papers I might write, and she was just a good friend.
I don't like that they get the hand-me-down textbooks and the athletic equipment when not say. And there was a lower court opinion that had said this, but Brown at the Supreme Court didn't say that the problem with segregation was its impact on white children as well. And that framing from the very beginning was quite offensive to a school of thought in black intellectual and political life, which said, wait. Are you saying then there's something wrong with our kids? So that tension, right, has been there in black politics since there's been black politics, and there's been black politics since there's been black people. So that tension has been there from the beginning. And this is how one of the ways in which it plays itself out, and Michelle really sketches out those intellectual traditions and the political history. That's one of the things I love so much about this book, is it traces that lineage so well.
Yeah,
and the people who, oh, sorry, go ahead.
No, as I said, that just was really important to me. I've had people ask me, well, why did you spend so much time doing that? And the answer is, how could you not?
Yep.
Right, how could you not? This is
But
not.
so many people have not. So you say, how can you not? But I don't think you're giving yourself enough credit when you say, how could you not? How could you not? Right? But lots of people have. So I'm sorry.
No, that's fine. I mean, that's where this becomes personal too.
Yeah.
Right? Because I didn't grow up in a Clegg home, right? And everybody who knows me knows that. But what I did grow up in was a black home. And so to me, what you have to have is an appreciation for the full experience, the fullness of the black experience, even if you don't agree with it, right? You cannot enter into a conversation and act as if the black community is a monolith. And not only is that wrong, and I think it's morally wrong, it also leads us into the wrong place to be able to understand the law. And that was what I was trying to do, was really to bridge that, to bring that into a conversation about the law and how we got the litigation and why it ended up being in the place that it was. The other piece that gets left out is the class element.
Yes.
And I try in different portions of the book to be able to talk about that as well. And that's another piece of the conversation that I think that we have to have. And so I think you're exactly right. When you were talking, I was thinking a lot about Verda Bradley, and that was that she's the one who lent her name to the lawsuit, and that's what really brought her into this litigation, right? I mean, she had seen how the school that she was sending her children to basically got fewer resources, and I think based upon the information that we have in the record, she comes to the NAACP and she's interested in this litigation because she thinks that if there are white students who are there, or in particular white parents who are there, she's going to have better access to resources for her children, right? Mm-hmm. And that is the classic sort of green follows white element, and that is a piece that you sort of see that's sort of woven throughout this conversation, and I think it has to be there to be able to understand the law.
Right, but you also, your story of the plaintiffs reflects the diversity of approaches within the black community and even the white community to integration, right? There's one white plaintiff in Bradley, but it's not like every black plaintiff has the same idea about what integration is going to
I think that's right.
accomplish, and you tell that story here, I think, really effectively. And I assume you did so intentionally.
Yeah, I did, and that was just a labor of going back and looking at what was in the record, looking at the newspaper articles, and really trying to find out what were people saying, and when were they, what was their rationale for being part of this lawsuit. So
the lawsuit is filed, right? And I think you've talked some about how there's an approach to, well, we got to deal with the state law. That the sponsor of the state law was Young, right? And he intended for it to be struck down as unconstitutional. At least he thought it was, right? So there's an interesting story there, but we can skip over that. Let's go over that because it's really the second story in the lawsuit, the second theory that becomes the driver of the litigation. So. Yeah, and we'll just make sure that we're clear on this, which was what started the lawsuit and then sort of what actually propelled it. What starts the lawsuit is you can't vitiate a school desegregation plan by law. You can't do that. That's just wrong. That violates Brown. But what really drives the lawsuit is
this larger question of running a public school system with almost 300,000 students that's separate and unequal. How do we prove it? Does it violate Brown? And what's going on with respect to other litigation. So you're starting to see a little bit of other litigation in other locales. Hasn't really percolated up to the Supreme Court yet, but what's happening when cases are being brought in other places in the North and the West is the defendants are saying, well, you know, as I said before, we're not responsible because the neighborhoods just happen to be segregated. And so ultimately, what the NAACP does is it says, let's figure out a way to take that defense away. Let's take that defense away from the defendants. Let's put on a case, a school case, but within that school case, we're going to have a significant housing element, right? We're going to explain why it is that black folks live where they live in the city of Detroit. And so if you try to layer on a neighborhood school rule on top of it, why that must necessarily generate segregated schools. So the idea is to take away this idea that, well, there's just, you know, neutrality, we didn't do it, we didn't mean it, we're not responsible. And so what this does is you know, many times when you're litigating, you think you're litigating one thing, you think it's going to be a relatively easy case, and then the case just becomes more and more complicated the more that you learn. And so what they ended up doing in the housing portion of the case, and why the book is called The Containment, is because they put on a bunch of evidence having to do with our country and having to do with Northern Jim Crow. And when I started writing this book, I didn't know that I was going to write a book about Northern Jim Crow. This book is basically about how we maintained and created Northern Jim Crow. That's what this book is about. And that's what the litigation was about. So how did it happen? Let's walk through the different kinds of mechanisms. Let's talk about what redlining was. Let's talk about what the security maps were. Let's talk about how that affected actual neighborhoods in the city of Detroit. Let's talk about segregated public housing. Let's talk about racially restrictive covenants. Let's talk about even after Shelley versus Kramer says you can't use racially restrictive covenants anymore, that local title companies are still reporting those covenants even after 1948. Let's talk about the state's involvement in terms of requiring that real estate salespersons actually have a code of ethics and then effectively endorsing a racist code of ethics. Let's talk about the idea that there are two racially separate real estate associations. This is way before the internet, so if you want to get access to listings, you've got to be able to get them from somewhere, but black brokers are being boxed out of the listings. They cannot show homes in white neighborhoods to black families. And then this is happening, and so blacks are being contained into city center, they break out, they go a little bit further, they get recontained again, and of course, this is the story that they're telling inside of the school case. Well, what's the school case, you might ask? The school case is, well, how exactly did the school authorities prosecute segregation in the schools? That is, we're going to let white students be able to transfer out of black schools. We're going to actually engage in having certain feeder programs that if you're in elementary school or if you're in junior high, you're going to have to go to a school for your race. We're going to have different kinds of student assignment policies. All of that is happening. So you've got the housing case and the school case. That's the litigation that I detail in the second third of the book. And it's masterful in terms of what the NAACP does in terms of putting this case on.
And it's also a reflection of why this case had such potential to dismantle what you're calling Northern Jim Crow, right? Because Detroit is not unique.
No.
Right. Ta-Nehisi Coates writes about this in Chicago. I mean, it is a story.
Detroit, Chicago, Milwaukee, LA. Yeah, this is standard operating procedure, right? And this is the part of our history that I think, if my book only had the impact of being able to sort of put a thumb on the side of the actual story, it would have been worth it to write it just for that. Because we're in the midst now of sort of trying to decide what we think actually happened. And so the lawyers sort of sketched this all out. And this is right. This is sort of the way that we maintain Northern Jim Crow across the country.
There's a striking part of the book that's about just visualizing this.
Yeah.
right? And so there's the map, and I want you to talk about the map.
Yeah.
And there's also the wall. And there's a picture in this book that, for me at least, I just had a visceral reaction to it when I saw it. I mean, I was so grateful that you put it in the book.
They wanted to put it on the cover.
Yeah.
And I was like, no.
Yeah. I can understand why the answer was no, but
Yeah.
but can you talk about the map and also?
Yeah, let's talk about the judge, too.
Yeah, sure.
So I'm sort of talking about these litigators. They're all great. They're wonderful. Oh, nice. But there's many themes in the book, but the other theme in this book is the importance of judges. And in the importance of judges, not judges who are in our party, not judges who agree with us, but judges who are open to being persuaded by facts, right? That is a good judge. Not a Democrat, not a Republican, but someone who's open to being persuaded by the facts as they're put in front of them. And you have that here with Judge Roth, who's a Hungarian immigrant, incredibly interesting guy, quite conservative, part of the conservative branch of the Democratic Party in Michigan, who is extremely skeptical of this case when it first gets filed and basically tells the plaintiff to get out of his courtroom. And he is someone who, over the course of this case, started out basically saying, I don't believe this. I don't think there's a thing called Northern Jim Crow. I want you to get out of my courtroom. Who by the end of this story and the end of his life is one of the nation's leading proponents of school desegregation. And it's quite a transformation. One of the things I think helped him get there were the maps. So this is also thinking about from the perspective of lawyers in litigation. Sometimes a picture tells 1,000 words, and the plaintiffs made a really smart decision to put up a series of maps behind the judge. And the maps were the census overlays. As you know, we do a census every 10 years. And the census from 1940, 1950, 1960, 1970, huge maps that are blown up, and they're sort of in the judge's sight line. And they show what I explained to you in terms of the containment of black folks living sort of in the center, breaking out by 50, by 1960, and then by 1970, excuse me, black folks are now, the containment line is the jurisdictional boundary of the city of Detroit. And I think that those maps had a huge impact on him. The other thing you asked about, sorry for a second, was the wall, which you said you had a visceral reaction to. There's a segregation wall not far. Actually, I'm going to have to stop talking for a second.
Okay.
You talk.
I'll describe it. It is a wall. It is how long was it? It was
half a mile long.
Half a mile long, and
6
it
feet
literally
high.
It was a 6 feet high, at least a foot thick, maybe more than that, that separated a black neighborhood from a white neighborhood, right? I mean, that a literal physical separated wall that was built precisely to separate, precisely to segregate, right? And so the story that the lawyers tell in all of these details is one of state, local, federal action, private violence, all constraining, all containing, all to explain why it's not just choice, right?
It's not just choice. Right, and so again, thinking about this from the perspective of what they have to prove is they've got to prove that segregation happened by law. They have to prove de jure segregation. They can't just say, well, it's de facto. They've got to be able to say that, in fact, it's government policy. And the wall represents that. It also was about 1.5 miles from my house. I never knew that it was there. And I didn't know why it was built, and it was built so that a white developer would be able to get access to federal housing funds, and the only way to be able to do that was to build a wall between the pre-existing black neighborhood there and the white area, the white development that he wanted to develop.
Okay, so we're gonna fast forward.
All right.
We've got the story in the lower court, which is successful beyond, I think, the plaintiff's imaginings in a way, the plaintiff's lawyer's imaginings at least. The emergence of the metropolitan remedy, which wasn't necessarily the way the plaintiff's lawyers framed the case at the beginning, but it emerged in part through the judge being transformed, through another lawyer who was representing white citizens who had initially opposed any of this, and that lawyer's transformation, right? So there's a lot of people who are being affected in the case that the plaintiff's lawyers are putting on so brilliantly, and it leads the judge to consider the metropolitan remedy, and of course that's ultimately where we started.
Yes,
right?
it is where we started. And so just one thing on the lawyer that you mentioned, a guy named Alexander Ricci, who is the lawyer for white interveners. These are white folks in the city of Detroit who intervene in the lawsuit, Citizens Committee for Better Education, and what they wanted was to prevent citywide desegregation. So they intervene in the lawsuit to protect neighborhood schools. And there's transformations in a couple different ways. The lawyer for that group ends up sort of starting to think that, number one, he's going to lose the case, and so if he's going to lose it, he wants to get out ahead of it. But then second, I think actually beginning to understand sort of how the city of Detroit is constructed. He'd grown up in Detroit, he'd been born there. And so the way that the idea for this metropolitan remedy actually gets into the judge's brain is through his openness in terms of sort of what he's seen in terms of the constitutional violation, but it's also not because of the plaintiff's lawyers, not because of the NAACP, but because of the white intervener group who say maybe 5, 6, 7 days into the housing portion of the trial, you know what, wouldn't it be great if in fact this case wasn't just confined to the city of Detroit? What if this was actually a metropolitan problem? And we have a lot of different kinds of metropolitan issues. We could treat it and have a metropolitan solution. So I think that's probably the single most surprising thing I found in my research, was that the way in which this gets into the judge's brain comes from white interveners who wanted to try to maintain their white neighborhood schools in northern Detroit, who turn around and say, well, wait a minute, if we're going to lose this case because it's a constitutional violation, because Brown was violated, let's bring everybody in, and let's bring the white folks from the suburbs in too.
Yeah. So that's that is what takes this case essentially to the Supreme Court, right? It is, and I'm both mindful of time and mindful of your voice.
Yeah, I'm feeling better.
I think we can skip over the intermediate appellate court
Yeah, I think we
decision
can.
for a sec.
Yeah.
Except maybe to tell a little bit about how the housing evidence starts to become kind of de-emphasized as the litigation goes through,
Yeah, I mean, it does and it doesn't. The key point is to understand that the Sixth Circuit Court of Appeals effectively upheld the trial judge's determination a couple of times. And I think it goes back to the point you were making about that there were always choices. That's the key part that I think I'd want to get across, which is, we could talk a little bit about, the ways in which the housing evidence was used by the Court of Appeals, and whether when it got to the Supreme Court they actually had to consider it. But the Supreme Court could have considered this at any time. And I would put that aside and simply say that that housing evidence was available to be used to the extent that the court was willing to say that the breadth of this remedy is justified because the housing market exceeded the scope of Detroit, right? Housing markets are regional markets, and much of the idea that folks, were locked into the city of Detroit, that meant they couldn't go to the suburbs, and in fact, the state was on the hook here. And so that was all, it was baked in, and the question really became for the court whether it was going to recognize that or not.
Okay, so when you think about the Supreme Court decision, and maybe this is a question for both of you,
Okay.
think about what are the most significant things that it fails to do, that it misses, that the fundamental flaws in the court's decision. I mean, maybe that requires saying a little bit about how they actually dealt with the evidence in the trial court. But when we leave that decision, given everything you've uncovered, how did the Supreme Court really fail? That's not the right question.
Well, no. I'll give the technical holding in the case, and then I'll talk about how it failed, and then I'd love to hear your thought on this too. The technical holding in the case is that Brown's fine, constitutional violation. We don't disagree with that. but the scope of the remedy has to be constrained to where the violation was found. And if the constitutional violation was in the city of Detroit, then the constitutional remedy has to be there too. And so the remedy cannot exceed the jurisdictional boundaries of the city of Detroit. And so if you want to bring in all these suburban school districts and 800,000 suburban school children or all the additional children, you can't do that, right? The remedy, there has to be a close relationship between the remedy and the violation. Now, what do I think the court missed? For me, the most important thing the court, I guess, missed or didn't talk about is the history, right? It's how we got there, right? So and I would love to hear about sort of why Milliken put you on the ground as a law student. But you could read that case and not have any idea of what we've just been talking about for the past 45 minutes. You would have no idea about any of this. And so it's what's not in the case in some regards that's more important than what's in the case. And it leaves the reader with the impression that Northern Jim Crow basically doesn't exist, that it wasn't a governmental policy. This was just something that was happening within the city of Detroit, and that it needs to be dealt with there. You have no sense that this was a nationwide problem. You have no sense about how this happened. You've got none of the housing or geographical or spatial evidence whatsoever. It gives a misleading version and a misleading idea of our nation and our nation's history and our urban and suburban areas. So that's what I think the court missed.
Yeah, I won't say too much on top of that because I agree. I think I would say what you asked me, Michelle, why was I kind of laid low? And I think part of it was because as somebody who had studied American history and as somebody who was a child of civil rights workers who was raised on this, I knew all this story. I mean, I didn't know all the details that are in this book, but I knew the story in broad strokes of redlining. I knew the story in broad strokes of wealth hoarding, of making it possible so that black families were not able to have houses that accumulated value, which then would allow them to move. I knew about not just I knew about the violence that black families faced when they tried to move to white neighborhoods. And so I knew, and I had been raised on the idea that the government was complicit in all of that. So this kind of fake, the way the opinion proceeds is, one, to not write about any of that history. I mean, it just takes it all out of the case. And once you take that history out of the case, then it seems a little bizarre to be asking for the remedy that you're asking for. The other thing that it does is it treats as sacrosanct in some ways these district lines, these municipal lines, the city and the city school district and the suburban. Those are all creatures of the state. That's the state of Michigan that is making all of that possible. Cities don't have power as against the state. The state is in charge. So this kind of fake, well, it's just here, but it's not over here, so the state's not responsible, so we have to limit and Marshall called that out, right? Marshall called that out and called out the perverse incentives that it created, which is basically, okay, all you have to do is get outside the Detroit City District, white family, and you're good.
And you're good.
You're good. So that's why I couldn't countenance it.
Yeah, I mean, Marshall's dissent is it's a thing. And, the other thing in it that I really appreciate, and I talked to the trial judge's clerk I interviewed, he says that the court's doing a gigantic disservice to the trial court judge.
Mm-hmm.
And it's it's really a moment to think about, again, we talked about this a little bit, the importance of judges, being open to being persuaded. And the way in which the judge was being, the trial court judge was being portrayed as if he was this sort of crazy, like Max Black sort of, ideologue, and that's just not who he was. And I know it. I know who this guy was. That's not who he was. But in order to be able to tell this counter story, this other story that doesn't exist in reality, somehow or another the judge was a casualty. And there's a bunch of trial court judges and different kinds of judges in my book, and one of the things I think I really, I have even more respect for how difficult judging is. It's not calling balls and strikes, right? It's really complicated and it's really hard. And I think what the trial judge did in this case was a really hard thing to do. And not for nothing, it probably shortened his life. And so that's a part of this story as well.
So I want to break for questions, for a brief period for questions in a second. I want to ask you one last question, which is, you write a little bit about this in the book, which is, what does the world look like if Milliken comes out the other way?
So I try not to overclaim in this book. I think it's important not to say, well, if Milliken comes out the other way, it's kumbaya, we're all going to be holding hands, and it's going to be like that Coke ad, right? What is it? What's the song? Like to give the world Coke, something like that. Yeah. I don't think that's true. Instead, what I say is let's look and see what happens when we actually had meaningful metropolitan desegregation. And we have a couple of good examples of that. Best one is Louisville, Kentucky, right? I think if Milliken comes out the other way, a couple things happen. There were a number of follow-on cases, copycat cases, that were following in the wake of Milliken versus Bradley that I think would have gone forward, but the air went out of them instead. I think that the NAACP spent almost $1 million in today's money to be able to put this case on, and there would have been more effort to go and then try those cases, and they would have gone forward. Would there have been a backlash? Absolutely. There would absolutely have been a backlash. And our constitutional history and our history has been cyclic and one of cycles. But one of the things I think I've grew to appreciate is that while you're having the backlash, kids are going to school. And while you're having the backlash, they're forming relationships. And while you're having the backlash, you're stabilizing neighborhoods. And while you're having the backlash, some folks are learning that maybe this integration thing isn't quite so bad. And so, yeah, I think there would have been a backlash, but I also think that it would have taken us a step closer to what Brown's promise, I think, actually was, and a step closer to the kind of nation that I'd like to believe we can have.
Okay. Question?
Can I ask one question?
Yes.
This is not about this. This is more about the process, because we have a lot of students in the audience, and some of you all will be writing research papers, maybe writing law review or law journal articles, maybe writing books one day. And I guess this is a question about your writing process. Yes. And I'm wondering if there's anything that you learned in this process of working for so many years on a book that is such a massive accomplishment. Are there sort of process? Is there something you kind of learn in the research or writing process, something that was important to you that you would want to pass along to maybe somebody who's in graduate school, or someone who's thinking about becoming a professor, or somebody who's has a big writing project on the horizon?
Yeah. Well, I mean, I see a bunch of my older research assistants here. First of all, you can't do it by yourself. I don't think you can accomplish something of this scope on your own. Mm-hmm. Whether it's getting support from your family, from your coworkers, from the young lawyers in your life, whoever it is, you're just not going to be able to do a project like this solely in isolation. I think the thing I learned the most was to not give up. And there was a particular song I would listen to in the morning when I would go to work. And I just wouldn't give up. And I remember coming into this building during COVID. And I got permission to do that, or maybe I didn't. But you know, I double masked when I got on the train, and I came in and did this work in the buildings I needed to be in here to have access to whatever I needed to have access to. And I did that during COVID because I had a deadline. And so all of you will face that in your work life. You're going to have a big project. You're going to have something that you need to do. You're going to have something that you think you may not believe that you can do that thing. And I'm here to tell you that you can do that thing. You can do that thing. And I think that there are lots of little things I learned. I learned how to use an archive. I learned how to think about I learned how to tell a story. I learned how to sort of foreshadow. I mean, all the sort of writing techniques that I didn't have that I developed. But mostly I think it's about believing in your ability to be able to complete the project and knowing what you're doing is a thing that needs to get done. And that's what I would say to all of the young lawyers here.
In the back there.
Hi.
Your book. So the title, containment in one sense, but you might think about the flip side, which is the courts sort of containing the fallout across the country, right? You see yourself say, this succeeds, you have other cases that are going to copycat, and you start looking at a broader sort of cascading set of effects. And I wonder if in writing this book you have any sort of insights or something you might offer about judicial management of big structural systemic cases like this. You know, we had the sort of CASA case, we had these other cases about the judiciary sort of intervening in these big social ways. Do you have any thoughts?
I mean, that's a question that could go in a bunch of different directions. I mean, from the perspective of sort of district judges doing like large case management stuff to sort of how the Supreme Court thinks about what its job is. I mean, I heard a lot of different things in there. I think I might just go back to what I'd said before, which is the qualities that we want to have in a judge are the most important thing, and then it's about can they actually do the difficult stuff in front of them, right? But when I say the qualities you want to have in a judge, the qualities are obviously a strong intellect, but they are empathy, they are an understanding of the world. They are not necessarily about agreeing with me or agreeing with whomever, but understanding the scope of the judging process in terms of how it affects people's lives. All of those kind of skills. There's actually a little piece in the book that I write about what it means to be a good judge and all the different elements. And I think I start with those kind of first principles and then move to the question of, okay, you know, what needs to happen in any particular case? Because I think it's sort of like character is destiny. I think that without those things, you're not going to get to the question of sort of how should we think about case management? How should we use, you know, what about the shadow docket? All of that kind of stuff. I mean, is there a strict requirement for reason giving? Right? I think where you come out on those kinds of things really begins with these sort of fundamental character and intellect questions that I think are most important. Hey, Betsy.
Thank you so much. I have two questions. My first question is, what song were you listening to? My second question is, so all of this discussion of Milliken in the book and tonight makes me think about teaching law students Supreme Court cases. And what are we doing? All the history and everything that happens in the trial court is left out of the decision. And like maybe everybody can really change the law professor
So the answer to the first question, it's an instrumental sung by a saxophonist named David Sanborn, who just recently passed, and I can't remember the name of it. I think it's Lotus Blossom. The second question is, as you may know about me, I'm a bit of a traditionalist in many ways, and I think what we actually provide students is really incredibly valuable. One of the things I've started to do, and I think some of my old students are going to laugh really hard when they hear this, is they're like, now she does this. Now I have a lot of slides, right? Beforehand, I didn't have a lot of slides. But I think for the intro to con law class I have now, I think I've got like 1,000 slides. And the reason why is that you can throw some of that history up on the slide and still be able to maintain pace as you're teaching. I think that, you know, it's really hard to think about how you would be able to teach every single Supreme Court case and all the concurrences and all the dissents, particularly given the fact that over time the court has engaged in, since the rise of word processing, cases have gotten much longer, and the fact that they've got 4 fantastic lawyers who are working with them, they're longer, there's having to piece together even what the holding is becomes problematic and difficult. So I think you're going to have to do that editing, but I think you can use PowerPoint in a really meaningful way to bring some of that history to life, and then still be able to pull out what the holding is and to have a meaningful conversation. So that's the way that I'm kind of squaring that circle.
Let me just say, it's really good to see you again, and congratulations.
Thank you.
You took my question about
Now
what
I know
the
it's a
song,
good question.
about what the song was.
Yeah.
I have a comment. For those who don't know me, my name is Tanya R. Kennedy. I am a 92 alum in Associate Justice Appellate Division First Department. And
It's wonderful to have you here.
it's wonderful to be here. And I agree with everything that you said about what makes a good judge. Let's remove knowledge of the law. We know that. But you hit something that's very key about having an open mind, about being willing to hear the facts. And when you talked about compassion, there were some of you, I'm sure you've heard me speak here before. When I talk about the history, you need to have your finger on the pulse of the human condition. Because when you do that, you understand all the dynamics. So the gentleman who talked about case management and all of these things, that comes into play when you have your finger on the pulse of the human condition, coupled with being relevant. And what do I mean by that? Yes, of course you're going to look at the case law, the statutes, all the other things. But there are other things that you have to read to open your mind and to be knowledgeable, to relate to not only the people who are in front of you, but how they got there. So I'm on board with it.
Thank you.
Thank you.
You know, it'd be a fun next book for you.
What would that be?
Would be to take, I think it would have to be a district court judge, but it could be a kind of a profiles in courage or profiles in open-mindedness. So you take 3 or 4 judges who change their minds over the course of a litigation, right? So you would obviously, you would need to have some good evidence to try to understand, you know, and so it would have to be historical, right? It couldn't be current, because you wouldn't know that they had necessarily changed their minds. Obviously you have one, but you know, you could go get some more. So
You want to do that together?
let's talk.
Let's talk.
I am tempted to give you, well, I feel obliged to give you the last word if you want it. I also would want to be mindful of time and say, do you want a last word?
Other than to say thank you, and I see the dean has arrived, so thank you so much. It's wonderful to be back here. That's really what I would like to say.
It's been wonderful to have you,
Yeah.
and let's thank Michelle. And